The distinguished guests, your lordships, kindly take your seats on the dais. Please sit down, everyone. Success is not final. Failure is not fatal. It is the courage to continue that counts. Good afternoon, ladies and gentlemen, esteemed judges, and distinguished guests. I, Ananya Shrivastava,
and I, Ishan Agarwal,
extend a very warm welcome to the final rounds of this prestigious National Moot Court Competition 2025. After rigorous preliminary rounds, intense quarterfinals, and exceptional semis, we have arrived at this decisive stage where the finest teams will contend for victory. Today, we witness not just a competition, but a testament to legal acumen, persuasive argumentation, and the art of advocacy.
it is our utmost honor to have an esteemed panel of judges with us today, whose expertise and insights will guide the final verdict of this prestigious moot court competition. Allow us to introduce our distinguished panel. It is an honor to introduce Honorable Mr. Justice Mahesh Chandra Tripathi, a distinguished judge of the Allahabad High Court. His Lordship is an alumnus of Lucknow University. Previously too, His Lordship has held several eminent positions, including serving as Additional Chief Standing Counsel for the state of Uttar Pradesh. His Lordship has also represented various prestigious institutions such as the Kanpur Development Authority, Kanpur Nagar Nigam, UP Food and Essential Commodities Corporation Limited, among others. His Lordship continues to serve with distinction as a permanent judge of the Allahabad High Court. We are truly blessed in your presence, sir. We welcome you, sir, with a huge round of applause, and I would like to request our Professor Adesh Kumar to welcome sir with a bouquet of flowers.
Thank you, sir. With the utmost respect, we extend a warm welcome to our next esteemed judge on the panel, Honorable Mr. Justice Ajit Kumar. His Lordship currently serves as a permanent judge of the Allahabad High Court and is a distinguished alumnus of our own Faculty of Law, University of Allahabad. Over the course of his legal career, His Lordship has gained extensive experience practicing in civil, revenue, service and constitutional matters before both the Allahabad High Court of Judicature and the Supreme Court of India. Presently, His Lordship also holds the esteemed position of being the administrative judge for the Aligarh district. We are truly honored to have you, sir, with us today, and I would request Professor Adesh Kumar, sir, to welcome your Lordship with a bouquet of flowers.
Next, we have Honorable Mr. Justice Saurav Srivastava, who is currently serving as a permanent judge at the Allahabad High Court. His Lordship is an alumnus of Avdesh Pratap Singh University, Rewa, and has built an illustrious legal career, holding several key positions in public service and advocacy. In 2019, His Lordship had assumed the role of Chief Standing Counsel for the Government of Uttar Pradesh, further strengthening his position as a trusted legal representative for state affairs. Currently, His Lordship holds the esteemed responsibility of being the administrative judge for the Sonbhadra district, where he continues to uphold the principles of justice with dedication and diligence. We welcome you, sir, on the dais, and I would like to request our Dean Professor Adesh sir to welcome sir with a bouquet of flowers.
Honorable Miss Justice Nand Prabha Shukla is a distinguished permanent judge at the Allahabad High Court. She embarked on her judicial journey with her appointment as an additional judge. Recognizing her judicial acumen and commitment to justice, Ma'am was subsequently elevated to the position of permanent judge. Currently, Your Lordship holds the esteemed responsibility of being the administrative judge for the Lalitpur district, where Ma'am continues to serve with dedication and integrity. We are honored by your gracious presence, Ma'am, and I would request Adesh Kumar sir to felicitate her with a bouquet of flowers.
It is an honor to have with us Honorable Mr. Justice Kshitiz Shailendra, who is serving as a permanent judge at the Allahabad High Court. Sir has an exemplary academic record, holding a science degree, an MBA equivalent postgraduate diploma from Dehradun, and a law degree from KGK College, Moradabad. Previously, His Lordship has practiced for over 20 years, specializing in civil, criminal, service, revenue, land requisition, and PIL matters, among others. His Lordship currently serves as the Administrative Judge for Sant Kabir Nagar District. I would like to request our Dean Professor Adesh Kumar sir to welcome him with a bouquet of flowers. Thank you so much, sir.
Now that we are aware of the bench... Now that we are aware of the bench adorned by our guests of honor, we are ready to proceed towards the final rounds. We request the court masters to kindly come forward and state the rules of the round.
If your Lordship permits, may I narrate the general instructions in the court. A good afternoon, distinguished jury member, learned participants, and the court officers. Welcome to the final round of National Moot Court Competition of University of Allahabad 2025. I am Vaibhav Singh.
And I, Vartika Singh, serving as a court master for this round.
Before we commence, I will be briefing the rules and procedures to be followed in the courtroom. Rules regarding courtroom decorum. All individuals present in the courtroom are expected to maintain strict decorum and professional conduct. Mobile phones and electronic devices must be switched off and set it on the silent mode. Spectators must remain silent through the proceedings and are not allowed to interfere with the session. Teams are prohibited from revealing their identity or institution's name at any point during the proceedings. Rules regarding time allocation and oral pleadings. Each team have 50 minutes to present its arguments, and remaining time is for the rebuttals. Time shall be strictly adhered to, and exceeding the time limit is subject to the discretion of the judges. Thank you.
Now comes the rules regarding timekeeping. A first bell will be given at 15 minutes over, followed by the second bell, which will be given after 30 minutes over. Third bell will be given at 5 minutes remaining, that is after 45 minutes gets over, and speaker must conclude their arguments in between, after 45 minutes gets over. A final bell will ring after the expiry of allotted time, that is 50 minutes, and speaker must conclude with the prayers if he has not done already. Now, judges may add their discretion, they can allow the extension. Now, rules regarding the conclusion of the rounds and post-round instructions. After the completion of the arguments, all the teams must remain seated and until the judges leave the courtroom. No participants are permitted to approach the judges personally for their feedback or scores. With that, now we are ready to begin the session. May I kindly request the speaker for the petitioner to approach the podium and begin with the arguments.
The council solicits permission to begin. Much obliged. Am I audible?
Hello.
Am I audible? Hello. The council solicits permission to begin. Much obliged. Greetings to the honorable bench. The council seeks permission to address the bench collectively as your lordship with the special permission of your ladyship. Much obliged. The council is appearing before this honorable Supreme Court of Allahabad in the matter of Apsara Kumari versus State of Kosala Pradesh on behalf of the petitioner under the writ petition filed under Article 32 of the Constitution of Allahabad. Your lordships, this case is not merely about legal technicalities, it is about the sanctity of individual liberties in the face of an overreaching state. There are 4 main issues involved in the present case. The council will be dealing with the first and the second issue, speaking for 26 minutes, while my co-counsel will deal with the third and the fourth issue, speaking for 24 minutes, respectfully reserving 3 minutes for the rebuttal. The council seeks permission to begin with the statement of facts. Shall the council begin with the statement of facts? Much obliged. In response to the rising threats, the government of Kosala Pradesh enacted Kosala Pradesh AI-powered Public Security Act, herein referred to as KAPAPSA, a law that promises safety, but at what cost? It allows for AI-driven enforcement mechanism, preventive detention, and strict surveillance measures. The petitioner, a journalist, was detained under KAPAPSA following the publication of a critical investigative report. The state claims her reporting incited unrest, yet where is the evidence? She stands before this court not as an offender, but as a symbol of democracy under siege. She challenges.
Sorry for the interruption.
It's all right.
Because these are the facts, it should be audited. Yes.
Am I audible properly now? Am I loud enough?
Middle of the podium. सही नहीं है आपके वो स्टूडेंट है
Hello.
it should be audible to the candidate or the students those are sitting the last one. That should also see what is the fact.
Hello.
Hello.
Yes.
Am I audible now?
Yes. Now you may start.
From the beginning?
Yes, you may start.
Much obliged. Greetings to the honorable bench. The council seeks permission to address the bench collectively as your lordship with the special permission of your ladyship. Much obliged, your lordship. The council is appearing before this court of Supreme Court of Aryavarta in the matter of Apsara Kumari versus State of Kosala Pradesh on behalf of the petitioner through a writ petition filed under Article 32 of the Constitution of Aryavarta. Your lordships, this case is not merely about legal technicalities. It is about the sanctity of individual rights in the face of an overreaching state. There are 4 main issues involved in the present case. The council will be dealing with the first and the second issue, speaking for 26 minutes, while the co-counsel will deal with the remaining 2 issues, speaking for 24 minutes. The council seeks permission to begin with the statement of facts. Much obliged. In response to rising security threats, the government of state of Kosala Pradesh enacted Kosala Pradesh AI-powered Public Security Act 2024, herein referred to as KAPAPSA, a law that promises safety, but at what cost? It allows for AI-driven enforcement mechanism, stringent bail provisions, preventive detention, and stringent surveillance measures. The petitioner, a journalist, was detained under KAPAPSA following the publication of a critical investigative report. The state claims her reporting incited unrest, yet where is the evidence? She stands before this court not as an offender, but as a symbol of democracy under siege. She challenges the act as unconstitutional for violating fundamental rights under Article 19, 21 and 22 of this Constitution. With the permission of the Honorable Bench, the Council would now begin with the issues. Much obliged. Your Lordship, the first issue pertains to whether KAPAPSA violates fundamental rights. The Council will establish the unconstitutionality through the following arguments. Submitting the first limb of the argument, that KAPAPSA violates Article 19 by imposing unreasonable and disproportionate restrictions on freedom of speech and that exceed the reasonable restrictions permissible under Article 19 subclause 2. In addition to this, the KAPAPSA violates Article 19 by violating freedom of movement through the preventive detention measures. If the bench would move to page number 55 of the petitioner's compendium, that is flag 5, is the bench with me? Yeah, yes. In the case of Shreya Singhal versus Union of India, your lordship, if you refer to the highlighted part, this honorable court has held that speech restrictions must be narrowly tailored and directly linked to maintaining public order. However, in case of KAPAPSA, through its arbitrary preventive detention and death penalty provisions, it cast an excessively broad net, curtailing dissent and failing the test of reasonableness, all in the guise of reasonable restrictions. KAPAPSA also undermines the established freedom of press. In the case of Romesh Thapar versus Union of India, that is page number 63 of the compendium, flag 12, this honorable court reaffirmed that restrictions on free speech and media must be based on clear and specific grounds. In Thapar's case, the court struck down a ban on magazine that was critical of the government, since the government failed to demonstrate a sufficient link between Thapar's publication and an actual threat to public order. Similarly, in the present case as well, your lordship, the government of Kosala Pradesh has failed to establish proximate connection between Apsara Kumari's investigative report and the alleged public unrest. As per para 15 of the Moot prop, if the bench would refer to para 15, the state merely speculates that her reports contributed to growing dissent without any direct evidence of incitement or unlawful conduct. The state, on the basis of intelligence reports, states that she was advocating for anti-national ideologies. However, there was no direct evidence for the same. Therefore, the justification of her surveillance and detention under KAPAPSA remains unconstitutional. Your lordship, what the KAPAPSA does is alarming. It replaces due process with prediction. It punishes individuals not for what they have done, but for what they might do, compelling self-censorship out of fear of state retaliation. This was reiterated in the case of S. Khushbu versus Kanyamal and another, where it states that chilling effect caused by excessive state surveillance and disproportionate restrictions on speech creates an atmosphere of fear that discourages journalists, activists, and even ordinary citizens from expressing mere dissent or opinions. This honorable court, in the case of Anuradha Bhasin versus Union of India, also recognized that restrictions on speech must be proportionate and narrowly tailored to prevent undue restrictions. KAPAPSA, through its preventive detention, that is section 4 of KAPAPSA, if the bench would refer to page 2 of the prop, through its preventive detention and also the mass surveillance provision, that is section 7, does the opposite. It expands the scope of state control without providing clear guidelines on what constitutes a threat to public order. Vague and undefined provisions enable selective enforcement, allowing the state to criminalize dissent under the guise of national security and protection of public order. Submitting the second limb of the argument, that CAPAPSA infringes upon right to life and personal liberty established under Article 21. The preventive detention measures under Section 4, allowing detention for 180 days without trial. Section 4 clearly states that it granted the state the authority to detain individuals for up to 180 days without trial if they are suspected or participating in promoting activities that pose a threat to public order. However, this threat to public order is a vague provision. In the case of Menka Gandhi versus Union of India, flag number 8 of the compendium, this honorable court have already stated that any deprivation of liberty must adhere to just, fair and reasonable provisions. The surveillance provisions, however, under section 7 of CAPAPSA lack procedural safeguards and breach the right to privacy of their citizens. The oversight committee used as a safeguard by the state, saying that it is an adequate safeguard. The oversight committee, it is just mentioned that there is a specialized oversight committee. However, there is no composition disclosed, and who constitutes the members of the surveillance oversight committee is also not disclosed, which shows there is a lack of transparency. Additionally, if the bench could turn to page 2 of the paragraph 6 of the Moot prop, it details about the night curfew provisions. Paragraph 6, your lordships. It details about the night curfew provisions and unrestricted AI-driven data collection of all citizens. Your lordship, this AI surveillance is not limited to tracking detainees or suspects. It operates as a mass data collection system, infringing upon privacy rights. Additionally, in the case of K.S. Puttaswamy versus Union of India, page number 22 of the compendium, the highlighted portion outlines how the case lays down threefold test for assessing law's constitutionality. That is, that is legality, necessity and proportionality. Your lordship, CAPAPSA fails on all three prongs, making it unconstitutional. Legality. There is no statutory framework ensuring judicial oversight, making it arbitrary. In addition to that, the legitimate aim and necessity posed by the or defended by the respondent, saying that it is the concern of national security or public order. However, CAPAPSA's broad and vague provisions target dissent rather than genuine threat. Talking about the proportionality, since there is no adequate safeguards and the surveillance is overreaching, it enables sweeping powers of preventive detention and mass surveillance without any meaningful checks. In addition to this, coming to section 12 of CAPAPSA, that is page number 3 of the Moot proposition, it very clearly states that it provided for the imposition of death penalty in cases where a detainee's activities were deemed to directly threaten the sovereignty or security of the state. Your lordship, this honorable court in the case of Bachchan Singh versus State of Punjab has ruled that capital punishment must be reserved for the rarest of the rare cases. Now, imposing death penalty for things that have not been, for crime that have not been committed yet, just on the sake that it threatens the sovereignty or security, and that is also, in addition to that, there is no clear terms as to what constitutes this or what leads to the death penalty imposition. Thus, your lordship, the CAPAPSA is unconstitutional on this ground as well, section 12. Submitting the third and the final limb of the argument, that CAPAPSA violates Article 22 by allowing prolonged detention without judicial oversight. The bare reading of the provision of section 4 of CAPAPSA says that it provides for detention under 180 days. Detention for 180 days without trial or judicial oversight. Your lordship, in addition to violation of Article 19, that is freedom of movement, the section 12 also violates Article 22, which talks about preventive detention. Article 22 subclause 4 very clearly mandates that preventive detention beyond 3 months must be reviewed by an independent body, independent board comprising of officials equivalent to High Court judiciary. However, Section 4 of CAPAPSA substitutes this with an executive-led review committee which constitutes the senior police officials. Now, Your Lordship, the question arises, if the detention is done by the police, if the review is also done by the police, where is the stand of the judiciary, or where is the check that the biasness is not there? In the case of A.K. Roy versus Union of India, the Honorable Court ruled that preventive detention laws must include robust safeguards to prevent misuse. Yet CAPAPSA lacks clarity on what evidence stands or what evidence justifies such detentions. This act does not merely regulate law, but it creates a parallel legal system, bypassing the judiciary's constitutional role. Thus, CAPAPSA is unconstitutional as it violates fundamental rights and lacks procedural safeguards. If the Honorable Bench is satisfied with the submissions, the Council shall now proceed to the second issue. Much obliged, Your Lordship. Your Lordship, the second issue in contention pertains to whether surveillance provision under Section 7 of CAPAPSA violates the Digital Personal Data Protection Act 2023. The Council shall establish this conflict on the basis of twofold argument. The first limb of the argument establishes that Section 7 of CAPAPSA violates Digital Personal Data Protection Act by enabling arbitrary and excessive data collection, despite the online publications criticizing government policies in the present case of Apsara Kumari do not disturb public order or national security. Section 7 subclause C and Section 7 subclause H of the DPDP Act very clearly allows that data processing is allowed only when necessary for protecting sovereignty, integrity or public order. They also mandate that this data processing process must adhere to adherence to the principles of necessity and proportionality. This Honorable Court has previously held that public order refers to an aggregated disturbance affecting the general course of public life. However, in the case of Apsara Kumari, she merely exposed the potential misuse of CAPAPSA and the misidentification done by the AI system, which led to the unfortunate incident of killing of an hapless child, a 17-year-old child who was clearly innocent. Furthermore, in the case of Raj Naren versus State of Uttar Pradesh, this Honorable Court reaffirmed that Article 19 subclause 1 subclause A of the Constitution guarantees not only the right to speech, but also right to receive and disseminate information on matters of public importance. The freedom to collect and communicate information is an essential component under Article 19 subclause 1 subclause A. Since my client Apsara Kumari was a member of media, it was her duty to expose or to disclose the facts or the misuse of the potential misuse of CAPAPSA or the state. Since Apsara Kumari's publication was thus constitutionally protected, this exemption under Article 7 subclause C of the DPDP Act does not apply in this case. Consequently, CAPAPSA's surveillance provisions directly violate the DPDP Act and the data protection principle enshrined under it. Submitting the second limb of the argument, that the absence of judicial oversight in data collection under Section 7 of CAPAPSA directly contravenes with the procedural safeguards established in the DPDP Act. Your Lordship, the Data Protection Act mandates that personal data processing must be subject to lawful oversight. The DPDP Act was enacted in line with the K.S. Puttaswamy judgment, which upheld that right to privacy is a part of Article 21. However, Section 7 of CAPAPSA enables mass surveillance without judicial authorization, violating core principles of accountability, necessity and proportionality. In the case of Big Brother Watch versus United Kingdoms, the European Court of Human Rights and European Courts of Human Rights ruled that government surveillance programs must have robust safeguards to prevent misuse. Through this case, it can also be understood that the right to privacy and reasonable restrictions have been accepted globally. The subject is of serious and globally acceptable topic or concern. Similarly, as already stated in K.S. Puttaswamy, that the Honorable Supreme Court underscored the need for procedural safeguards in handling personal data. In the case of Union of India versus Manohar Lal Sharma, the court also ordered a technical committee to investigate Pegasus spyware misuse, reaffirming that even legal restrictions on privacy must be proportional to their objectives. The court also ruled that national security cannot be used as an excuse to evade accountability, which is very clearly evident from the Moot prop, from the present condition of Apsara Kumari and the stand of the state. Your Lordship, the power to watch is the power to control, and the power to control is the power to silence. Section 7 of CAPAPSA violates DPDP Acts by allowing mass surveillance without judicial oversight. Such overreach threatens data privacy and fundamental freedoms. If the Honorable Bench is satisfied with the submissions of issue 2. Indeed, Your Lordship.
Reconcile with the global concern you just said and the threat and security of the state. How do you reconcile? Because certain reasonable restrictions are often imposed. You said that the data privacy is being violated or it gets violated, whatever you say.
Indeed, Your Lordship.
His answer is vague. How you proceed to examine the reasonable restrictions that have been imposed, looking to effect the security of the state? Because there is a consent clause provided. The privacy part is concerned, there is a consent clause. Your private details are not exposed easily or generally unless and until you consent. How do you reconcile with the two?
Your
The global
Lordship.
concern of threat,
Pardon, Your
individual
Lordship.
threat to the state security, and then this AI use and the surveillance, etc. Then how do you reconcile with this? These are the reasonable restrictions looking to the threat concern.
Indeed, Your Lordship. The Council understands that the state, conditions of the state and the unrest and the issues of national security and public order is there in Kosara Pradesh. However, this reasonable restrictions also includes that there should be safeguards. Now, the contention of the Council and the petitioner is that the Kosara Pradesh, the CAPAPSA Act do not have safeguards to the data protection or the preventive detention. Now, it is the necessity clause of the Putta Swami case is thus fulfilled that there was concerns. However, when we come to proportionality, the test fails. And the main contention of the petitioners are this, that there is no safeguards and no judicial oversight to the provisions, and thus it can lead to executive overreach and misuse. Shall the Council proceed? The further arguments will be submitted by my co-counsel.
Hello.
The Council would like the permission to begin. Your Lordships, addressing the third issue, the Council will establish that the provision under the Kushala Pradesh AI-powered Public Safety Act, that is CAPAPSA, failed to uphold Aryavarta's commitments to international human rights obligations and violate the fundamental principles of presumption of innocence and also the established principle of bail not jail through a twofold argument. Submitting the first limb of the argument, it is submitted that CAPAPSA violates several international human rights treaties, particularly the International Covenant on Civil and Political Rights, that is the ICCPR, the Universal Declaration of Human Rights, that is the UDHR, and Convention Against Torture. Your Lordship, Article 9 of the ICCPR guarantees protection against arbitrary arrest and mandates that individuals deprived of their liberty must be promptly brought before a judge. However, Section 4 of CAPAPSA granted the state the authority to detain individuals for up to 180 days without trial, allowing prolonged detention without judicial checks. This violates the principle in Nekalev versus Belarus, where the Human Rights Committee reaffirmed that prolonged detention without judicial review violates Article 9 of the ICCPR. Furthermore, the mass surveillance provisions under Section 7 violates Article 17 of the ICCPR, which protects individuals from arbitrary state intrusion into their privacy by giving the state to use uncontrolled surveillance powers on individuals detained without the prior authorization of the court. The restrictive bail provisions and prolonged preventive detentions under Section 4 and 9 also violate Article 3 and 9 of the Universal Declaration of Human Rights, which affirm the right to liberty and protection from arbitrary arrest. The state brought surveillance measure under KAPAPSA infringe upon Article 12 of the UDHR, which prohibits from unwarranted interference with privacy. Lastly, KAPAPSA's provisions amount to psychological coercion and prolonged suffering, violating Article 1 of the Convention Against Torture, which prohibits the act of torture, including prolonged pre-trial detention under coercive conditions. The denial of procedural safeguards and the imposition of arbitrary surveillance contribute to fear and repression, breaching Aryavarta's obligations under the CAT. Submitting the second limb of the argument, KAPAPSA's restrictive bail provisions violate the fundamental principle of presumption of innocence and the established doctrine that bail is the rule and jail is the exception. The Supreme Court of Aryavarta has consistently upheld the presumption of innocence as a key principle of bail jurisprudence. In state of Rajasthan versus Belchan, this honorable court ruled that pre-trial detention should not be punitive and that bail must be a norm rather than an exception. In Nikesh Tarachand Shah versus Union of India, the court struck down a similar provision of the Prevention of Money Laundering Act, which was section 45, that burdened the accused to prove their right to bail, ruling that such a requirement was manifestly arbitrary and unconstitutional. Your Lordship, KAPAPSA section 9 imposes an undue burden on the accused to establish exceptional circumstances for bail. This requirement is not defined under the Act, that what would constitute an exceptional circumstance, given the executive the whole discretion. If the bench would refer to page 27, flag 11 of the Petitioner's Compendium, it would find the case of Jalaluddin Khan versus Union of India. This honorable court emphasized that bail must be granted in accordance with established legal principles and prolonged detention could not be justified based solely on the gravity of allegations. Thus, the Act is unconstitutional as it violates international human rights treaties, the presumption of innocence and the right to bail. The restrictive bail and mass surveillance under these provisions lack procedural safeguards and an oversight of the judiciary to prevent the misuse. If the Honorable Court is satisfied with the submissions of the third issue, the Council would like to proceed to issue 4. Much obliged. Your Lordships, addressing the fourth issue, the Council will establish that the state's negligence in ensuring the accuracy of AI systems amount to a breach of its sovereign duty to protect human rights through a twofold argument. Submitting the first limb of the argument, it is humbly submitted that protecting human rights is an essential sovereign duty of the state. Using artificial intelligence in law enforcement to strengthen security does not absolve the state of its obligation to uphold fundamental rights. The wrongful killing of Kishore Kumar, a juvenile boy of 17 years due to AI misidentification, is a clear violation of Article 21. The right to life under Article 21 is non-negotiable and the state is accountable for the negligence that leads to these violations. The inaccuracy in functioning of the AI systems identifying the individuals led to the killing of Kishore Kumar, exemplifying a grave injustice and a blatant violation of fundamental right to life and liberty by the state. In Nilabati Behra versus State of Orissa, the Honorable Supreme Court held that the state could no longer escape the liability for public law for violations of fundamental rights. In the present case, the government of Kushala Pradesh must be held liable as the killing of Kishore Kumar constitute a violation of right to life under Article 21. The right to life is paramount and any breach of this right attracts state accountability. In case of Severina Ribeiro versus Union of India, the Honorable Supreme Court held that the right to life and secure liberty guaranteed under Article 21 is so fundamental and basic that no compromise is possible with the said right. Therefore, the misuse of AI surveillance oversight and resulting of wrongful death amounts to gross negligence by the state, making it liable. Your Lordship, the Council pleads ignorance for the inconvenience caused. Would like the permission to continue. Therefore, the misuse of AI surveillance, lack of oversight, and resulting wrongful death amounts to gross negligence of the state, making it liable under public law remedies. The state negligence in deploying unreliable AI surveillance mechanisms constitute a clear breach of its sovereign duty to protect human rights. Submitting the second limb of the argument, the proportionality and necessity of AI systems enforcement must be questioned. AI enforcement without stringent oversight and accountability has led to violations of Article 21 and Article 14 of the Constitution. The unchecked and unsupervised use of AI policing without judicial oversight or robust mechanisms of redressal directly contravenes the doctrine of fairness and reasonableness as held in K.S. Puttaswamy versus Union of India. Any action infringing upon fundamental rights must pass the test of legality, necessity, and proportionality. The AI systems employed under CAPAPSA failed all three, resulting in arbitrary detentions and fatal consequences. By failing to ensure the accuracy and accountability of AI-driven law enforcement, that state has facilitated a system that disproportionately harms innocent individuals, just as Kishore Kumar. Thus, the state negligence in ensuring AI accuracy violates its sovereign duty to protect human rights. If your lordships are satisfied with the fourth issue, the council would like to proceed to the prayer.
Every technology has good aspects and bad aspects.
Yes, your lordship.
The AI tool is being applied, it's a very advanced technology.
Yes, your lordship.
Just for a stray case or a two, how can you term the entire provision to be bad? Or you can say that the proper safeguards have not been adopted. In every legal field, in every technology, it happens that certain good aspects are, certain bad aspects are. How do you rate this AI then? Suppose one incident has taken place or two incidents have taken place, but AI technology is being used very vastly and to the advantage of the state security. How do you assess it?
Your lordship, the petitioner here is contending the over-reliance of the state on the AI technology. The AI technology developed was relatively new. It was developed in 2024. And based on the information given on the AI technology, the officials shot a guy. And that information was wrong. The state might have arrested the child, should have taken him into detention. But shooting the child shows the over-resilience of the state in using this system and how the ignorant the state is in ensuring the reliability of the system and how to train their officials to use the system.
So it is not the fault of the AI, it is the fault of the concerned official who was taking permission from the AI and culminating into shooting that child. That might be arrested, as you said earlier, that might be arrested by the police officers. The entire AI system cannot be abused.
Indeed, your lordship, but the AI falsely took, if the lordship could refer to para 10 of the Moot proposition. Para 10 and 11. Later on, which reads that, later on, a reputed investigative journalist, Aksara Kumari, dug deep into the incident and revealed that shook the whole nation. Kishore Kumar was not shot by mistake. If we could please move to para 11. He was identified wrongly by the state police due to the botched up AI software used by the police to identify criminals. Your lordship, the boy was wrongly identified by the state as Don Kishore Kumar, and due to this they shot the child thinking that he's the Don of it. So the AI technology is also at fault here.
Suppose if you find there is some shortfall in the provision or something, then what are your suggestions on how to plug that one? Do you have any suggestion? Someone, if you coin any new act or a new provision, then definitely there would be some shortfall. Later on, gradually, once some loopholes and shortfalls comes, then definitely these are either by the court or through a legislature. What do you find? What are the shortfalls? And how you propose to plug that shortfalls?
Your lordship, the biggest shortfall of this act is that no use of judiciary. The judiciary is completely moved out of the question. In section 9 of this act, the state is directing judiciary to allow bail only in exceptional circumstances. There are previous bail provisions in CRPC. The judiciary is competent enough to grant bail or not. The state is no one to tell the judiciary that you should apply bail in exceptional circumstances, or you are questioning the competence of the judiciary. In section 4 of the act, it also states that the individuals can be detained up to 180 days without trial. Your lordships, there is a law in India, that is the Unlawful Activities Prevention Act, which is heavily criticized. It also states that after 90 days, you have to take the permission of the courts to move it to 180 days. This law removes that also. So the judiciary should be taken into account while upholding these provisions. This is the suggestion to take into consideration the judiciary. Your Lordship, I would like to proceed to the prayer. In light of the above submissions, petitioner respectfully prays this honorable court to adjudge and declare that Section 7 of the CAPAPSA is ultra-vires as it contravenes the Digital Data Protection Act 2023 by permitting data collection without judicial oversight, violating the fundamental rights to privacy. Secondly, the restrictions on bail and use of surveillance does not align with Aryavarta's international obligations and presumption of innocence, and the right to bail are also violated. Thirdly, the state has failed to exercise due diligence in deploying AI-powered enforcement under CAPAPSA, which has resulted in the breach of its sovereign duty to protect human rights. Last and the foremost thing, to declare that CAPAPSA is unconstitutional as it violates the fundamental rights guaranteed under Article 19, 21 and 22 of the Constitution of India, or pass any judgment, declaration that the Honorable Court may deem fit in the interest of justice, equity and good conscience, all of which is humbly prayed. It was a pleasure.
Hello, am I audible? The Council seeks permission to collectively address the bench as Your Honours. Much obliged. May it please the Court, this is Council number 1. The Council seeks permission to proceed. Much obliged, Your Honours. Your Honours, this is Council number 1 on behalf of the respondents, and the Council will be dealing with issues number 1 and 4, and my co-counsel shall be dealing with issues number 2 and 3. Much obliged, Your Honours. Your Honours, at the outset, the Council contends that there is no maintainability in this particular petition, as there is a sufficient efficacious alternative remedy which is provided under Article 226 of the Constitution, which is to file a petition before the High Court, which has a similar concurrent jurisdiction as that of a Supreme Court. Additionally, Your Honours, moving to the first issue, which is that there is no violation of fundamental rights, and hence CAPAPSA 2024 should not be considered as unconstitutional. The council shall be proving this particular argument in 3 prongs. First, that there is no violation of Article 19. Second, that there is no violation of Article 21. And thirdly, that there is no violation of Article 22, Your Honours. Moving to the first prong of my argument, that there is no violation of Article 19. Your Honours, it is most humbly submitted that the right which is enshrined as per Article 19(1)(a) is not an absolute right, and reasonable restrictions are also provided under Article 19 Clause 2, which includes public order and security of the state. Your Honours, it is most humbly submitted before this honourable bench that the publication that was made by the petitioner in this particular case, as well as her social media activity, directly contributed to the disruption of public order, as she has actively used social media platforms, news portals and online publication to incite mistrust amongst the citizens towards the government's actions, and some of her published works have also been considered as unverified claims, and the same has led to the protest being turned violent. Moreover, Your Honours, as per paragraph number 15 and 16 of the Moot proposition, it is evident that the videos which were circulating online purportedly show individuals inciting mobs using her publications as a justification. Your Honours, in the landmark case of Romesh Thapar versus State of Madras, a very essential principle was drawn, which was that a speech can be restricted when it directly threatens the security of the state. Your Honours, it is argued by the council representing the state that Ms. Apsara's publications directly threatened the security of the state. It is also submitted, Your Honours, that in the present case, the intelligence reports submits that Ms. Apsara Kumari was allegedly associated with certain activist groups who were advocating for anti-nationalistic ideologies as per paragraph 15 and 13 of the Moot proposition. Your Honours, in another landmark judgment of Ram Manohar Lohia, the Constitutional Court has narrowly interpreted the term public order, and it has held that any speech can be restricted if there is a proximate link between the speech and the public order disruptants. Your Honours, it is humbly submitted that there was a proximate link between the speech, between the right that was that the state is, that Ms. Apsara Kumari is alleging to have performed here, that is her expression, as well as there being a violation of public order, and hence the speech can be restricted under Article 19 Clause 2. Additionally, Your Honours, there is always a presumption of constitutionality in favor of a particular law, and the onus is upon the petitioners who are claiming that the act is unconstitutional. Moving to the next prong of my argument, Your Honours, that is there is no violation of Article 21. Your Honours, it is most humbly submitted that preventive detention and surveillance provisions as provided under CAPAPSA are not violative of Article 21, as they are imposed through due process of law, and they serve as a compelling state interest in maintaining public order as well as the security of the state. Your Honours, it is also to be considered that in the very landmark judgment of Maneka Gandhi versus Union of India, it was held that Article 21 rights can be restricted if the procedure is fair, just and reasonable. Your Honours, it is submitted that CAPAPSA does ensure that there are procedural safeguards provided, as it provides for a bi-monthly internal review committee, ensuring that the detentions are made not in an arbitrary manner but are also periodically assessed by this particular committee. Additionally, Your Honours, in the landmark judgment of PUCL versus Union of India, the Supreme Court has upheld the electronic surveillance and interception of communications, and has held that if it is backed by procedural safeguards, then in that case it is valid. In the present case at hand, Your Honours, CAPAPSA provides for a specialized oversight committee as under section 7 of the law, and the same permitted electronic surveillance of her mobile phones, laptops, etc. And it is also to be noted, Your Honours, that this particular data that is being collected, as was alleged by my learned counsel appearing for the petitioners, that there is no criteria for how much of data can be taken over with regards to surveillance. It is argued that the specialized oversight committee helps in the deletion, in the automatic deletion of the data that was collected if that data is not related to the active investigation, and hence all the procedural safeguards are kept into force. Another argument that was raised by my learned opposing counsel for petitioners was that there is a death penalty provision as per section 12 and hence it should be considered as unconstitutional. Your Honours, it is to be identified that as per section 12, we are not restricting the judiciary to uphold it, to apply its judicial mind, as the section provides for death penalty only if it meets the criteria as has been given under section 12, which includes activities of the detainees were deemed to directly threaten the sovereignty or the security of the state, and the alleged conspiracy or incitement to violence that could lead to significant harm or loss of life. And if it is not, if the act of the detainee is not falling within the ambit or the grounds under section 12, then the judiciary has the power to apply its judicial mind and proceed with investigations as per general law, which is the BNS, etc. And hence there is no restriction on the application of judicial mind, and by that virtue section 12 is not unconstitutional. Moving to the next prong of my argument, Your Honours.
Just hold on please. What happens if the section 12 retracted and the section 12 has been proved by the prosecution? What will be the role of the judiciary or the judge once dealing with the section 12? Whether it is compelled for the judge to pass the death penalty or to lesser it down. This provision is not available in the Act. Kapapsa.
Much obliged, Your Honours. Your Honours, that the council is trying to contend here that only if this particular threshold is met, the law is providing that death penalty should be imposed as a punishment. However, the council is nowhere contending that the judiciary has been taken the liberty of applying its judicial mind as per the provisions of BNS. Much obliged, Your Honours. Moving to the next limb of my argument, that there is no violation of Article 22. Your Honours, it is most humbly submitted that Kapapsa is not violative of Article 22 because it is in alignment with the well-established procedure as has been provided under Article 22, Clause 4, Subclause A. Your Honours, what my learned opposition counsel has argued is that it is not in alignment with the UAPA. It is to be established here, the council is trying to contend here, Your Honours, that as per the requirement under Article 22, there has to be an advisory board set up, which is also taken care of by this particular law, as the State Human Rights Commission members do constitute the judges, do constitute High Court judges or the people who are, have been or can be appointed as the judges of a High Court, and hence the procedural compliance with regards to there being an advisory board set up has been necessarily met here, with regards to which the law should be upheld. Another thing is that my learned opposition counsel for the petitioners has argued 180 days without a trial provision to be unconstitutional or depriving of fundamental rights. Your Honours, it is submitted that this is a preventive detention law. We are not trying to arrest the particular person, and hence 180 days is given as a outer limit, and this provision as per 22, procedure as per 22 is still kept intact, that the punishment can be 90 days. If it is to be extended, then the bi-monthly internal reviews committee can review the same and then decide whether or not such detention can be extended to a period of a further time limit. Much obliged, Your Honours. Your Honours, moving to issue 4, that is...
Before you move to issue 4, you have talked of reasonable restrictions and the procedural safeguards. Now coming to section 4 and then section 7, one of the argument advanced was that a specialized oversight committee which is conceptualized under section 7, there is no such provision as to who will be the members of this specialized committee, oversight committee. And then there is no doubt, there is a presumption regarding the validity of a law. But in order to test the law on the principle as contained under Article 19, then the absolute discretion cannot be given in the hands of the executive. So what are the safeguards? How do you protect this section?
Indeed, Your Lordship, this issue will be dealt with by my co-counsel in her arguments. Much obliged, Your Honours. Your Honours, it is argued that the AI system is not inaccurate and hence there is no negligence of the state in order to ensure the accuracy of the AI systems, and there is no breach of the sovereign duty of the state. Your Honours, this shall be presented before this court in two limbs. First, that the state has a sovereign duty to protect the human rights and fundamental rights of the citizens, and second, that the state has not been negligent in ensuring the accuracy of the AI systems. Your Honours, one of the arguments that was raised by my by the learned opposition counsel is that they brought up the case of Neelabati Bhera. Your Honours, it is to be noted that first of all, the facts of the case are very different with regards to the facts at hand. Secondly, Your Honours, the opposition counsel has no locus standard to bring the case of Mr. Kishore Kumar before this honorable court, because in the Neelabati Bhera case as well, the locus standard was given to the mother of the accused, and hence there is no locus standard that the petitioners are coming under with regards to Kishore Kumar's death. Additionally, Your Honours, moving to the first limb of my argument, that the state has a sovereign duty to protect the human rights as well as to uphold the fundamental rights of its citizens. Your Honours, the state is duty bound to ensure that the state security, public order and the protection of its citizens is intact as per Article 38 of the Constitution. Your Honours, the AI assisted law enforcement is necessary and proportionate response to the public security threats, organized crimes as well as digital radicalization. Your Honours, as per Article 6 of the ICCPR, it mandates the state to take proactive measures to safeguard the life of the people, and hence CAPAPSA is very much in alignment with Article 6. Additionally, Your Honours, the assertion that AI violates human rights and overlooks the it basically overlooks the broader aspect with which the CAPAPSA in the first place was enacted, which was to protect the citizens and to ensure the rule of law. Your Honours, the deployment of AI technology is a rational, scientific as well as a proportionate response to the emerging security challenges. This also falls within the sovereign functions of the state in order to maintain law and order. And any unintended harm that is caused by the AI system does not amount to an actionable negligence, Your Honours. Additionally, it is also argued that my learned opposing counsel for the petitioners has brought up this point that it was indeed because of the AI system that Mr. Kishore Kumar was shot. Your Honours, it is argued that the encounter of Mr. Kishore Kumar is within itself an isolated act. The CAPAPSA nowhere gives the law enforcement authorities, that is the police, in order to go about doing encounter of the people who have been identified under this particular law. The AI technology is only adding as a assistance with regards to identifying whether there is any evidence against the particular detainee or not in the first place, and hence it also helps to ensure that the fundamental rights and human rights of the detainees are upheld. Additionally, Your Honours, if that was the case, there can be a separate trial that can take place with regards to why the police authorities went for encountering Mr. Kishore Kumar, and that is not the present case at hand before us. Much obliged, Your Honours. Your Honours, secondly, the state has not been negligent in ensuring the accuracy of the AI systems. It is most humbly submitted that the state has taken all the reasonable as well as necessary steps to ensure that the AI system is accurate and is with accuracy deployed under CAPAPSA. The state has never intended for AI to be the sole or the ultimate authority to make any decisions with regards to the law enforcement, and it is merely acting as an aid and not as a replacement for human judgment. And also, Your Honours, this AI powered surveillance under CAPAPSA does not inherently violate the fundamental rights, as it is subject to oversight, audits as well as human review. Additionally, Your Honours, from paragraph number 8, it can be seen that there were extensive mandatory training programs which were rolled out to educate the law enforcement officials about the ethical use of the AI tools, which also included ensuring that the officers to understand the limits of surveillance and give respect to the individual rights. All of which is most humbly submitted. Now my co-counsel shall take over for the remaining of her issues.
that this legislation came into force on 30th August 2024.
Indeed, Your Lordship.
And this incident took place the very next day, on 1st September. And state has admitted its guilt that there was a mistaken identity. So
Indeed.
how will you meet out this negligence part?
Your Ladyship, with regards to this, the state is only contending that there was a mistake with regards to identification of Mr. Kishore Kumar. Again, the Kapapsa.
Circumstances, again repeat, then what, how will the state meet out these situations?
Much obliged, Your Ladyship. Your Ladyship, as per paragraph 8 of the prop, the council just cited, it is clearly if the council could just take 1 second. Much obliged.
While raising your arguments, you have already, demonstrated all these things what
Indeed, Your Lordship.
my ladyship has already questioned.
Indeed, Your
But
Lordship.
somehow you are lacking in your answer. It has already been argued earlier
Indeed,
also.
Your Lordship. Your Lordship, the council identifies that, however, the council will explain the question put forward. The council was just trying to identify the paragraphs from the proposition. Council, please ignorance. Much obliged. Your Ladyship, as has been already argued by the council, that as per paragraph number 8, the algorithms of this particular AI technology are regularly updated to improve the accuracy, and the audits are also conducted to identify the potential biases. Also, Your Ladyship, the police has acted beyond the power, and that is a separate issue altogether which will be tried in a separate trial, which is not a matter before this honorable court.
You justify the arrest of this lady,
Yes.
as you are arguing that the killing of that juvenile was a separate issue.
Indeed, Your Lordship.
So now we are concerned with this arrest of Apsara Kumari. That is the main issue before
Indeed.
us. So 1st of September is the incident. The lady published something and immediately you arrested. See point number 15 of the Moot proposition. The state police claimed to have received intelligence that Apsara Kumari was allegedly associated with certain activist group. See, the power to arrest is there, but in what circumstances it would be exercised? Hurriedly, very hurriedly, you admit the guilt, genuine case of mistaken identity. You have the power, all right. Entire act may not be ultra virus. Some provisions may be struck down by the court in appropriate proceedings. So you are defending the entire legislation.
Indeed, Your
Some of
Lordship.
the provisions may be ultra virus. See, the justification, now forget about the killing of the boy. You just justify the immediate arrest of this lady who was investigating, who was a genuine reputed investigative journalist.
Indeed,
So you
Your
are
Lordship.
defending the arrest, exercise of the power to arrest, immediate, on the basis of certain inputs which you claim to have, because you were like acting that nobody should investigate into this, although you admit that it is a case of genuine. Now you try to improve upon that AI is good and we are improving then you leave everything on that committee. Article 22 comes into play, then proviso is there that in the cases of preventive detention it will not be applicable. But there are checks and measures. How do you justify that? What was the material before you? Somebody came to investigate and then you just washed her away. Arrest, then justifying that 180 days you can detain that lady.
Much obliged,
No
Your Honor.
intervention.
Much
So
obliged,
the-
Your Lordship. Your Lordship, as per paragraph number 18 of the proposition, there was a prima facie evidence which was available against Ms. Apsara Kumari. Additionally, Your Lordship, she was not arrested by the virtue of Kapapsa. Kapapsa is merely a preventive detention law, and she was arrested under maybe BNS because that's a matter of trial, Your Lordship. What we are contending here is with regards to the constitutionality of Kapapsa, which is only a preventive detention law, and she has not been arrested as per the provisions of Kapapsa.
Now, AI is in addition to
Indeed.
that technology is there, then definitely the investigation
Indeed, Your Lordship. Indeed, Your Lordship. Indeed, Your Lordship. That's exactly what the council is trying to contend, that AI is merely used as a tool to aid and is not a punitive mechanism. If Your Honours are satisfied, much obliged. It was an honour to argue before this bench. Your Honours, is the council audible to the bench? Much obliged. May it please this court, this is counsel number 2 on behalf of the respondents. If the bench is satisfied with the arguments put forth for issues 1 and 4, counsel seeks permission to move into issue 2. Much obliged, Your Honour.
There was some query made
Yeah.
before council in answer.
Yes, Your Lordship. With respect to the Oversight Committee, now coming into issue 2, under the DPDP Act, section 4 provides that a data fiduciary, which is the state in the present case, can collect the data of a data principal, which is the individual being detained, as understood from the wordings and the letter of the law as under section 7 by 2 ways, either by way of consent or by way of legitimate purpose. Where there is consent, you have the requirement of notice amongst other obligations of the data fiduciary. Here it is asserted that the state is collecting data under section 7C and section 7H, as pointed out by the counsels for the petitioner, for the legitimate purpose in furtherance of securing the integrity, sovereignty and security of the state. With respect to another exemption which is provided expressly under the DPDP Act, Your Lordships and Your Ladyship, under section 17 clause 1C, where any state or instrumentality of the state is processing personal data in the interest of prevention, detection, investigation or prosecution of any offence, the obligations of the data fiduciary, which is chapter 2 of the DPDP Act, will not be applicable. Here, section 7 under the KAPAPSA operates within the exemptions of section 17 1C as well as section 7 subclause C and subclause H, where the data is being collected with respect to the people being detained in furtherance of the objective of the Act, which is to provide for protection of public order as well as security of the state. Could the council proceed? Much obliged, Your Lordship. Much obliged. Here it is serving the interest of national security and public safety and the prevention of crime and protecting the rights of the individuals at large, as is necessary in a democratic society. This act has come into place only after less intrusive methods of state control proved insufficient. In furthering this argument, counsel also takes the help of Richard Posner and his analysis as to how, even though the internet can be used for lawful and unlawful transactions, the concerns of national security weave seamlessly into the cyberspace. To quote him, privacy is the terrorist's best friend, for the internet with its anonymity and the secure encryption of digitized data, when combined with that anonymity, make the internet a powerful tool of conspiracy. Even in the present case, it has to be noted that the modus operandi of the petitioner largely worked through her social media platforms and online publications through which she was publishing unverified claims, which were again used by mobs in justifying as to why they were protesting, many of which even turned violent, as inferred from the facts. Now coming into the Puttasamy test requirements, as spoke.
It's just one question.
Yes, Your Lordship.
What was the time gap in between arriving at a conclusion that she was engaged in antisocial activities, she was associated with these groups? You immediately see the dates and events, how the entire scene. Because we are concerned with Apsara Kumari, we will not divulge into that, the killing of that boy.
Yes, Your Lordship.
That was a fact admitted by the state.
Yes,
he
Your
was
Lordship.
not involved.
Yes.
To justify the use of all these tools, to justify the arrest of and detention of this lady.
Your
For
Lordship.
maximum period of 180 days, denying the bail, arguing on exceptional circumstances.
Understood, Your
Why?
Lordship. With
What
respect,
was the material? How quickly the state arrived at a conclusion that she was engaged in that? Intelligence reports are there.
Your Lordship, even though her arrest was made one day after the killing of Kishore Kumar,
Yes.
as inferred from paragraphs 3 and 15 of the Moot proposition, the state of Koshala Pradesh did have intelligence reports linking people to extremist ideologies. Apsara Kumar.
Earlier, so it was must be having that data earlier also, prior to this incident.
Yes,
What
Your
was the reason of not going for an arrest prior to killing of that boy? If the data was there, State Machine Act was there, data was there,
Yes, Your
antisocial lady was moving around, indulge in some activities. Immediately, the moment she enters into publishing something about this incident, then you utilize that data to justify the arrest immediately, associated with this. So you must be having prior data also.
Yes, Your Lordship, understood. But the council asserts that this is merely coincidental, as the intelligence reports that were being collected were over a year's period, which is how this act, which was initially an ordinance, subsequently became an act because of the increasing crime rates. The conditions of the society were such that it happens to be a coincidence as to how her arrest was immediately after the killing of Kishore Kumar. It has nothing to do with respect to the data that was collected. Could the council proceed? Understood, Your Lordship. Could the council please proceed? Much obliged, Your Honours. With respect to the Puttasamy test, now the 3 requirements under the Puttasamy are legality, legitimacy and proportionality. With respect to legality, the requirement is there must be a statute in existence. That is satisfied by Kapapsa, which was validly enacted by the state legislature. With respect to legitimacy, that requires that there is a necessity. Now, in light of these rising crime rates and increasing law and order violations, as once again in Moot Proposition paragraph 2, state surveillance is not just necessary, it is indispensable for maintaining public safety and national security. When crime becomes more organized, technologically advanced and widespread, the government must have the tools to prevent unlawful activities before they escalate into a full-blown crisis. And lastly, coming to the proportionality aspect. With respect to proportionality, there are 4 requirements. 1, that there must be a legitimate goal, which is satisfied by the preamble of the Act. 2, that there must be suitable means of furthering this goal. 3, there must not be any less restrictive but equally effective alternative. And 4, that the measure must not have a disproportionate impact on the right holder. With respect to this, even though the DPDP is not applicable to Kapapsa, the provision itself, section 7 itself, has multiple safeguards to ensure the same. One being the specialized oversight committee, wherein without their approval the state cannot collect data. It is not that the state can exercise the discretion at any point of time and collect any data. There is a due process which is under section 7 which has to be followed to do the same. Furthermore, there is also a requirement as to deletion of the data after a specified period or once the active investigation time period is over. This also ensures that data is not being retained, which again brings me to the fact that it is in congruence with the DPDP principles, that being data minimization and purpose limitation. With respect to data minimization, whatever data is being collected, it is used for the purpose of surveillance so as to protect the security of the state. And with respect to purpose limitation, whatever data is being collected, they are compartmentalized, they are not retained, and there are adequate safeguards in encroaching upon this right. And given the current circumstances where a lot of transactions happen through internet and global mediums, that is why there is a necessary for data valence as under section 7. If the bench is satisfied with the...
Are there any guidelines regarding data protection?
Your Lordship,
Does the Act talk about or refers to the rules anywhere?
As under the DPDP, there are rules that have been notified, but it hasn't been effected yet, as far as the council is aware of. But with respect to state surveillance, nothing in the rules that prevent...
The procedural safeguard aspect question remains unanswered.
Yes, Your Lordship. So what the council was trying to say is the procedural safeguards still come up with the fact that there is...
What are the procedural safeguards? Just saying is not enough.
Understood. So there is an oversight committee whose approval is required.
How does the oversight committee comes into existence?
Your Lordship,
probably the argument that was advanced by your other side. So the Act is absolutely silent. Discretion is absolutely given in the hands of the executive. And wherever you find a situation, the Supreme Court has been very categorical about it. The reasonable restrictions means laying down the guidelines, laying down the rules. You cannot vest this power with the discretion of the executive, that you exercise the manner you want. Then there are violations of fundamental rights, violation of liberties. That's the core issue that are being addressed.
Now it is to be seen who are constituting that committee. If there is a judicial member, then it's all right. Otherwise, it is in the hand of the executive, definitely there would be intervention.
Understood, Your Lordship.
Yes. So who constitute that committee, that is a decisive fact.
By way of collecting data, you are entering into right to privacy. You are collecting each and every data, and then you segregate the data with regard to the which is concerned with the national integrity or the national security. Otherwise, you are not. What are the measures to classify the data which has been collected broadly? I mean, if I am sending message to my wife, that has also been collected. And along with the same data with the transaction of some money to some unknown person. So these are all things what my honorable judge is saying, and making query before the learned counsel for the respondent is altogether missing.
Understood.
And that is another question. What are the safeguard if suppose someone is innocent and his data is collected? Data is collected, and suppose if the state is bent upon to implicate someone, and artificially he roped that person in that criminality or some civil consequences, you may say, and that data is being used against that. What are the safeguard to a public at large? If suppose if you are here to curb the criminality in the society, then it's all right. These data are used for that purpose. But suppose if it is used against a commoner, suppose the political vendetta, you collect the entire data and you use and misuse that. So what are the safeguard? And the Article 19 and 21, how these are to correlated with these fundamental rights of an individual?
Understood, Your Lordships. So as my co-counsel argued, with respect to 19 and 21, they are not absolute rights and they can be encroached where there are reasonable restrictions. Now in this particular case, with respect to the procedural safeguards, it's not that the data is stored even after they are proven innocent or guilty. Once the specified period elapses or the investigation stops being active, then the data is deleted. That is adequate safeguard to ensure that the data does not get further misused. With respect to the constitution of the Oversight Committee, although the letter of the law does not provide for the same, the council once again submits that under the DPDP Act, the state is exempted from the provisions of the DPDP, requiring that there is, meaning that there is no requirement with respect to consent. But here, by providing the Oversight Committee, it's an additional step that the state has taken in furtherance to balance the rights of the same. The council understands that the lack of, in the letter of the law with respect to the constitution of the committee might be an issue, but once again it is submitted that it is only a measure that is in furtherance of the same. Irrespective, under section 7C and 17(1)(c), the state does not require the consent of the data principle to.
There is another consequence. Suppose who is in the helm of affair and he, under his signature, the certain data are deleted. And suppose these data are required for the safety and security of a state. And this is being deleted on a behest of some committee or some individual. And how to reclaim that, and what are the safeguards in that aspect also. If these data are used for the safety and security of the state, and on one other hand, some data are being deleted, then what would be the consequence, whether you would be able to reclaim that data or not? This aspect would also come.
Understood.
There is a pros and cons of both the things.
Understood, Your Lordship. So with respect to that, under section 7, the Oversight Committee can only provide approval for collection of data. It cannot in itself provide permission to delete said data. That data gets only deleted once the thresholds of either specified period gets over or the active investigation gets over. Here, the only power that the Oversight Committee has been provided with is to allow for the collection of the data by the state. That too for the purpose of surveillance, which furthers the purpose of the Act. If Your Lordship is satisfied with the same. Yes. Council seeks permission to move into issue 3 if the bench is satisfied. Much obliged. Much obliged, Your Honours. It is humbly submitted before this bench that the restrictions under section 9 are in line with Aryavata's international obligations. And in this aspect, the submissions are being made in twofold manner. Number one, with respect to the international law obligations, and number two, with respect to the principles of bail not jail and presumption of innocence. Article 9 of the ICCPR, which is analogous to Article 9 of UDHR, guarantees a person's right to liberty and security. But at the same time, it also allows for deprivation of liberty, provided that there is a
procedure established by law. Apsara's detention and subsequent surveillance were in line with the process under the law in force. It is also to be noted that Aryavarta has expressly has stated reservations with respect to how Article 9 shall be applied into the Indian jurisdiction, in the sense that Article 9 of the ICCPR would have to apply in consonance with Article 22 of the Constitution of Aryavarta. With respect to Article 14 of the ICCPR, which is analogous to Article 11 of the UDHR, it provides for the presumption of innocence. Now, with presumption of innocence, there are three submissions the Council would like to put forth. Number one, that the fact that a person should be presumed to be innocent before proven guilty does not equate to an unconditional right to bail. In serious offences such as terrorism, organised crime or violent offences, the threat posed by the accused extends beyond their personal liberty and into broader concerns of people at large. The second implication is with respect to the burden of proof. In a criminal trial, to get someone convicted, you have to prove beyond reasonable doubt that said person has committed the crime. But with respect to a bail application, the court takes a different approach. When there is sufficient evidence to not grant it, the detainee cannot avail it. Section 9 is not a blanket restriction in the sense that bail will not be allowed. Bail will be allowed provided it meets certain exceptional circumstances. The third implication with respect to the standard of proof to justify pre-trial detention. Now, bail determinations are based on risk assessments and not definitive findings of the guilt. As the state had submitted, the individuals who are being preventively detained under KAPAPSA may also have the resources and network to evade prosecution of law, which is why there is such a greater threshold of restrictions placed as under Section 9. Even then, once again, the Council emphasizes, much obliged, Your Lordship. Even then, the Council emphasizes that it is not a blanket restriction on bail. Finally, under the United Nations Standard Minimum Rules for Non-Custodial Measures, it encourages the alternatives to pre-trial detention, which once again is met because, as the Council has been reiterating, bail is being provided under exceptional circumstances. Furthermore, Your Lordships, Your Ladyship, the bail restriction under Section 9 is constitutionally valid, as similar provisions can also be traced out into central legislation, that being the National Security Act of 1980, under which Section 14 limits bail to exceptional circumstances. It is to be noted in the case of Vijay Madan Lal Chaudhary versus Union of India, the court affirmed the validity of stricter bail conditions to further compelling state interest in tackling serious crime offences. The counsels for the petitioner had stated the case of Tarachand, wherein Section 45 of PMLA was struck down. But in this particular case, it was with regards to a substantive offence. KAPAPSA does not in itself create a substantive offence. It's merely a preventive detention law which is being enacted under the competence of the state legislature, being entry 3, list 3 of the 7th schedule with respect to a preventive detention law. If the bench is satisfied with the arguments put forth for issue 3, counsel seeks permission to move to the prayer.
I may put a query to you.
Yes, Your Lordship.
Bail is rule, jail is exception.
Yes, Your Lordship.
Right?
Yes.
Now come to Section 9.
Yes, Your Lordship.
Don't you think that the exceptional circumstances having not been defined as such, they give a very wide power to the executive to plead before the court that this being a special act, bail should not be granted? How do you explain it?
Your Lordship, with respect to that, ultimately a bail application is still being made before the judiciary, wherein the judiciary exercises the discretion as to whether or not allow it. In fact, if the council would contend otherwise, wherein exceptional circumstances can be read in to include multiple things as deemed fit by the court itself. It's not that the state, it doesn't provide the state an arbitrary measure to restrain bail, but rather an option for more judicial scrutiny with respect to what can be an exceptional circumstances. Does that satisfy Your Lordship? Yes. Much obliged. Counsel seeks permission to move to the prayer. Much obliged. Wherefore, in light of the issues raised, arguments advanced and authorities cited, the Honorable Supreme Court of Republic of Aryavarta may be pleased to dismiss the petition and impose any cost as it may deem fit, and or pass any other order, writ or direction it may deem fit in the interest of justice, equity and good conscience, all of which are most humbly and respectfully submitted. It's a pleasure and honor arguing before this bench.
sort of bridge was there.
May the council proceed, Your Lordship? May the council proceed, Your Lordship? It was a pleasure arguing in this court. Your Lordship, the respondents took the defense of Article 17, subclause C of the DPDP Act, stating that it allows data collection in interest of prevention, detective investigation or prosecution. However, Your Lordship, if the bench could refer to para 6 of the Moot proposition, it states that the data is not only collected of detainees or suspected people. It is collected of all the citizens in order to analyze the data to make crime-related reports. So this stands unreasonable, the stand of exception under Article 17 clause C, because since it is very much clear from the fact sheet that the data is collected not only of the detainees but of all the citizens. Additionally, Your Lordship, the respondents took the defense of K.S. Puttoswamy and stated that the enactment was legally enacted. However, Your Lordship, if the bench could refer to para number 7 of the Moot proposition, it clearly states that the ordinance was laid before the state legislature after 6 weeks of its meeting in the monsoon session. However, Your Lordship, it is to be noted that section 213 subclause 2 of the Constitution states that the ordinance automatically lapses if it is not laid down or if it is not approved by the legislature within the 6 weeks of the meeting of the first session. So the very contention of the respondent saying that the enactment from ordinance to act was legal stands unreasonable. Additionally, the petitioners questioned our writ petition filed under Article 32. The council accepts that there is an alternate remedy of 226. However, this does not bar the petitioners to approach the Supreme Court. Additionally, since this case does not only deal with Apsara Kumari, but the enactment of this law concerns the citizens of the large state of Kosala Pradesh, which is the most populous state of Aryavarta. So the contention that Article 32 does not stand in this is thus proves wrong. Thank you, Your Lord. Yeah.
So far as section 7 is concerned, if you read it minutely, then you will find permitted a state to conduct electronic surveillance on individuals detained. Firstly, they are to be detained, including monitoring of phone calls, social media and internet activity without prior authorization of a court of law, but after approval of a specialized oversight committee. Data collected under the AI system was subject to automatic deletion after so and so. So firstly, the condition is, you just said, they may collect the data of an individual. No, a person who is detained.
Indeed, Your Lordship. However,
Yes.
if you refer to para number 6.
So far as section 7 is concerned.
Yes, however, the question is of CAPAPSA as a legislation. If you refer
Yes.
to para number 6, which imposes night curfew, the last statement, it reads
The
as,
first and foremost condition is that person is to be detained.
Your Lordship, please, if you may refer to para number 6, it
Yes.
states that for the provision of night curfew, the last statement reads as, citizens' data was collected by the state on a large scale by using AI technology. So this states, there is no mention when it comes to the provision of night curfew that there was certain people or detained or in suspicion whose data was collected. So it was a mass data collection program or provision. This is what the respondents are contending.
Now you read section 7, that's why I wanted to clarify that one. It's only for
Apologies, Your
that.
Lordship.
It's all right.
Yeah.
Argued that the act was passed in a day. There was no discussion. What did you argue?
No, Your Lordship. The respondents are saying that the act before becoming an act was an ordinance, and the ordinance was laid before the state legislature after 6 weeks of its meeting in the monsoon session, which is in violation with Article 213 of the Constitution, which states that if ordinance is not laid or it is not validated by the legislature within 6 weeks since the meeting of the first session, it is automatically lapses. So where is the provision of legally enacted act, because the ordinance was automatically lapsed. This is what the respondents are contending. It was a pleasure, Your Lordship.
Just a minute, I may also clarify another thing. If you read the section 6 and 7, 6 says, it is in the backdrop that a empirical analysis of a crime-related data that the provisions of a night curfew from itna to itna was made in the ordinance. The police were authorized to identify the accused persons using the specifically developed AI technology. As a result, citizens' data was collected by the state on a large scale by using AI technology. This is for the purpose of a large scale of using AI technology for data. But the para 7 says the permitted state to conduct electronic surveillance. There is a difference. Data collection and the surveillance both are the different facets. Where an individual is identified by the state, this person should be checked, his activities are to be checked, he may be anti-national or indulging in some criminal activities, then the person is put at surveillance. That is the issue. So that portion is meeting section 7, and so far as the data 6 is concerned, it is of a AI surveillance, not surveillance, data collection. That is a difference.
Hello. Mass data collection by AI technology does not also implies that it can be used for misuse. So basically, the contention of the petitioners is that the protection or the defense used by the respondents under the exception of Article 17 subclause D of the DPDP Act thus stands unreasonable. This is what.
Council seeks permission to move into rebuttals. Much obliged. With respect to the first pointer,
She has some time limitation. She has some time limitation. 5 minutes. First of all, we would like to know your opinion against your own argument. If you have to defend, now you are defending, now you are against. What are the basic features which they have said? You are also harping on that. If that now the role of an advocate is changed.
Yes, Your Lordship.
Within 5 minutes, you just coin that, it should go.
Yes, Your Lordship. With respect to section 7 or the...
Because you must be thoroughly prepared in defending that.
Yes, Your Lordship.
Now you have to argue contrary to what you have argued that.
Yes, Your Lordship. With respect to unconstitutionality of the Act, section 3 talks about... If the council to proceed, much obliged, Your Lordship. With respect to section 4, authority to detain is up to 180 days. But as per the... It's done? Your Lordship, could the council proceed? Yeah, apologies for the inconvenience. With respect to section 4, state is being given the authority to detain an individual for 180 days. But as per article 22, only 90 days of detention are permitted. Where you have to extend beyond 90 days, the same has to be approved by an advisory board. The advisory board as provided under section 4 consists of your police officials as well as your representatives from the State Human Rights Commission. Now under article 22 of the Protection of Human Rights Act, where Section 22, apologies, where there are members of the judiciary. There is also a representative who is well versed with facts of human rights, which are a part of the SHRC. So by bringing a representative as such into the internal review committee under Section 4, that is a clear violation of Article 22, Your Honors. With respect to Section 7, the blanket surveillance which is being done with respect to the monitoring of phone calls, internet activity, social media, are all encroachments which are not proportionate. You are encroaching into the private spheres and self-expression of people, which are not permitted as under the Constitution, Your Honors. With respect to Section 12, where there is imposition of a death penalty, here the offense has not even taken place, because we are talking about providing death penalty to a detainee whose activity is deemed to have threaten the sovereignty or security of the state. And in doing so, that is also in violation of Article 21. Furthermore, the non-availability of another alternative with respect to the penalty that the judiciary can appoint, that is also, as in like if the crime is committed, the hands of the judiciary are tied. They can only impose death penalty. There is no other less restrictive alternative, which also fails the test of proportionality as under Article 21. With respect to the ICCPR and international human rights obligations, Aryavarta, having ratified ICCPR and UDHR and multiple other covenants, as also was stated by the counsels for the petitioner, they do have a duty to enact the same as under Article 51C, to foster respect to international treaty obligations and in the international treaty norms. So this is also in furtherance a violation of international human rights and norms as under issue 3. And with respect to ensuring the accuracy of the AI system, no matter how reputed the research institute is or whatever measures the state has taken, the fact of the matter still remains that an individual was wrongly identified and shot dead. And in doing so, the state has been negligent with respect to their duty of protecting sovereign rights of the citizens. If Your Honors are satisfied, counsel seeks permission to move to rebuttals. Much obliged. With respect to the first pointer that the petitioner raised, I believe the bench itself has clarified the same. As to Section 7, the data is being collected of the individuals that are detained. The collection of data under Proposition Paragraph 6, which my learned opposition counsel was referring to, is merely with respect to collection of the data, which is different from the surveillance aspect as under Section 7. With respect to 213, the council would, Article 213 and how the state has not enacted the law validly, it is submitted that 213 is the power of the governor to promulgate ordinances during recess of legislature. Here, there was no recess of legislature because the state legislature was in monsoon session, and it is not the governor that has promulgated. The bill was placed before the state legislature and validly enacted as a law. Lastly, with respect to the pointer for alternate remedy under 226, it is submitted that the powers of the High Court under 226 are wider than the Supreme Court, and this being a state legislation that should have been challenged before the High Court, as that is an efficacious alternate remedy, and the balance of convenience or the judicial convenience mandates that petitioners should not be wasting judicial resources per se. While the council is not trying to say that 32 is not a fundamental right, the mere submission that is being put forward is that they did have an alternate remedy which was not exhausted appropriately, all of which are submitted. That's all, Your Lordship. Thank you. Thank you.
It is indeed a tough battle of wit and wisdom. Thank you so much, Your Lordships, for your time and efforts. We request you to please proceed for refreshments at the second floor.
Kindly remain seated. Everyone, please be seated. Jai. The jury has left for high tea. The students, volunteers are requested to take the participants for the refreshments at the back side of the hall. Volunteers, please take the participants for refreshments at the back side of the hall. Student volunteers are requested to take the participants for refreshments at the back side of the Ishwar Topa Hall, Ishwar Topa premises.
वो आ रही है वही है ना भी कौन है हाँ वो है वो आ रही है ओके जितने भी लोग यहाँ पर हैं
मेमो मंगवाए थे, वो पीडीएफ फॉर्मेट मंगाए थे। तो जैसे नॉर्मली जो चेक होते हैं मेमोज, वो तो डॉक फॉर्मेट होता है कि आपने डॉक में डाला वर्ड में और फॉर्मेटिंग चेक कर ली उसकी सीधी, सब बराबर है कि नहीं। तो पीडीएफ फॉर्मेट में चेक कैसे होता है?
क्या हुआ?
हम डाउट पूछ रहा है मेमो वाला।
अच्छा,
जैसे आप लोगों ने मेमो जो मंगाए थे, वो आपने मंगाए थे पीडीएफ फॉर्मेट, और जनरली जो मेमो चेक मंगवाए जाते हैं वो डॉक मंगवाए जाते हैं, क्योंकि जो फॉर्मेटिंग चेक होती है वो सीधा आप डॉक अपलोड करो और फॉर्मेट देख लो कि सब सही है कि नहीं, हैंड्स में ह्यूमन है कि नहीं, मार्जिन है कि नहीं, लाइन स्पेसिंग है कि नहीं। तो अगर आपने पीडीएफ मंगाए तो वो चेक कैसे होंगे, ये पूछना था।
बताएंगे,
क्योंकि मतलब ऐसा ना, वो पीडीएफ आप देख नहीं पाओगे कैसे,
जैसे कन्वर्ट करोगे जब आप वर्ड में,
हाँ,
तो फिर वो ओपन वो जनरल डाउट था ऐसे।
हाँ जनरल।
Student volunteers, please take note, the refreshments are only for participants at the back side of the Ishwar Topa hall. You may proceed to have it. Participants के लिए security वालों से बोल